Hello there. Hi everyone, thanks for joining me. I am lcadilac and this is my weekly update of the Young Thug RICO trial out of Fulton County, Atlanta, Georgia. If you're not familiar, I am an attorney in Dallas and I'm just here for commentary. My favorite thing is to watch trials and to assess the lawyering of other lawyers and to share that with you. So if you're new, make sure you hit like, subscribe. Thank you for joining. Make sure you comment as we go through today. I love interacting with y'all. And also, thanks everyone for watching last week's video. We had a great turnout on that and I really appreciate it. So, diving right in. Have you ever met someone and think when they're speaking, like, do they hear their own words? Have any of you experienced that? I experience it all the time, but I feel that I experience that with this Judge Glanville, like, constantly. As you know, the timing of this trial has come to issue. So this week we're on day 52, 53, 54. I think there were only 3 days to this week of actual presentation. Okay, we're in week 16 of actual jury presentation. But the trial started 11 months before the jury got seated. It took them a long time to find a jury, which makes sense because it's going to be a long trial. So there's not a lot of folks out there who can, afford to come be a juror professionally for 2 years. So it took them a really long time to find the juror. Okay. We are 50-something days into presentation, and we've had less than 40 witnesses, or just about 40 witnesses, I want to say, and the prosecution has absolutely proved nothing. I keep feeling like maybe they're ramping up. Sometimes you do a little witness, little, and then you're ramping up to tell the complete story. You got to tell these little details first, and then the full story comes out. But how long are we going to ramp up for? Like, the ramping up you got to be ramped up at a certain point. So everyone is quite frustrated about how long this has taken. Now, if you ask me, the reason it's taken so long is because they've taken so many breaks. It doesn't actually have to do with the presentation of the prosecution or the defense. Now, certainly, the prosecution failing to hand over evidence prior to the beginning of the trial, as they were supposed to, that has caused delay. There's no doubt about that. That causes delay. But what really causes delay is when you say, let's take a 10-minute break, and you come back an hour and a half later. Or how about you tell the attorneys, let's be here Monday and Tuesday, and then switch it and don't actually come in until Wednesday because you had to go to a funeral. This is the judge. This is what the judge is doing. The judge is the cause of the delay. Period. That's me, like, reaching into the mic, really emphasizing. I almost took a sip of my mic earlier. Y'all, I am consistently trying to do better sound and better visual for you. The thing is I'm a really, really, really good lawyer. I am not a really good technologist. So as we move and progress on this channel, please bear with me. And just so you know, the more you watch, the more you like, the more you subscribe, the better chances I have of being able to buy good equipment. Okay? So, this is a fancy mic, but it picks up so much. Oh, and I think the background noise that someone commented about last week is probably just the air conditioning. I have a fan on. It's hot. It is hot in Dallas, Texas. I feel like it's hot being over 40. I'm an over 40-year-old woman, so I'm hot. Just the way it is. Okay, so the judge is Breaky McBreakerson over here talking about, oh, well, this is a delay and it's all your fault. It's like, whoa. Not to mention, like, last week, there was the witness who, Miss Love, went on about the text messages between her and the witness, and we're kind of going to get into that in a little bit here. But, like, then she started she recrossed the witness on her text messages. So her first thing was about this incident, and then there was a cross, and then her recross was about the text messages, and it was completely unrelated. It was completely irrelevant. And Glanville could have overruled, or I'm sorry, he could have sustained objections that would have stopped that line of questioning, but instead he didn't. And so now, this week, we hear a whole motion about how Love has made herself a witness, which is true, she has. And we have further delay. So Judge Glanville keeps talking about, well, this needs to go faster, but then simultaneously is the reason for the delay. Does the man even hear himself speak? I don't know. All right, so let's get into it. They finally came to work on Wednesday, I believe. Wait, hold on, I took notes this time. Oh no, they were there on Tuesday. I guess Monday he had the funeral. It's the other thing. Okay. I would never be a judge because that would force me to work for the government. I don't want to do that. I do judge, though, so just so you know, I'm constantly judging. But I wouldn't be a paid judge. So the other reason for that is if I had some kind of televised case like this, like, I have to tell everyone, I'm not going to be able to make it to your funerals. I'm not going to be able to do these things during this time. This is going to be a long trial. So you as the judge, you don't get to go, unless it's your wife or kid or dad or something. You can't go to your cousin's funeral. You're in the middle of conducting a trial. So anyhow, I don't know, guys. I did not elect this man. I don't know how they choose judges in Georgia. In Texas, we elect them, which has its own set of problems. All right, so Tuesday, they did the lyric hearing. So that's what we're going to go. We're going to go do this chronologically. Now, you might recall I did a video a few weeks ago. I want to say 2 weeks ago. The Supreme Court of of Georgia. Atlanta doesn't get its own Supreme Court. The Supreme Court of Georgia had made a ruling about a rap music video. And that kind of changed maybe whether or not the state can use lyrics against Thug. Now, certainly to me, I believe that music is art and we have a right to free speech, right to expression. I personally thought most of that crap that they're singing about is made up. I also like music without lyrics, so I say crap because like half the time I feel like the lyrics ruin the song. Anyhow, the defense is of course trying to say this is art and we can't prosecute on art. The prosecution is trying to say these are confessions, which is just absolutely crazy to me. So the new Supreme Court ruling, it was going to be interesting to find out how that would have, or if that would have any effect on the lyrics and whether or not they could come in, and it turns out they don't. So here we go. YSL Steel over here.
These lyrics with a certain crime. The closest they came is they told the court that trestle tree, that Jeffrey Williams said the word trestle tree, which is a section, a street where crimes were committed in this case. The fact that he is using trestle tree in a song certainly cannot be that he's somehow involved in that crime. In addition to that, the prosecution spent 4 months showing or trying to show that Mr. Williams is the leader of this gang. They have...
Oh, that's one thing I wanted to tell you. Those of you who are old enough to remember the O.J. Simpson trial, that entire presentation to the jury was 9 months. So a long trial is not unheard of. Like 9 months with O.J. was the longest I had ever heard of. But it's not unheard of. It's just probably not great. And we'll get into that in a bit.
Put on over objection Mr. Bean's recorded statement with Detective Quinn saying that Jeffrey Williams orders, he commands Mr. Murphy to do something. They put on Trontavious Stevens, who said inconsistently, but said...
This is a nice recap.
Jeffrey Williams is a member of the gang. They put on that Jeffrey Williams is the slime, the big slime, King Slime, rather, excuse me. They put on Detective Belknap. They are going to use, over objection, Detective Gaither as a gang expert on YSL. They're going to use Detective Dennis as a gang expert on YSL. Over objection, they're going to use Investigator Vivarito as a gang expert on YSL. And all of them make, for certain, over objection, Mr. Williams the head of this supposed criminal organization. So why did the lyrics have any probative value if it's simply cumulative? I'm trying to answer.
Okay, so probative value means like, does it actually show us something? Does it tell us something? Is it really part of the story? The things in a criminal court must be more probative than they are prejudicial. So prejudicial means that they would prejudice, obviously the jury against the defendant. Probative would be they help show a better story, and they will better help the jury understand. Cumulative is like, it's just a repetition. So YSL Steele is making the argument here, like, hey, they have a gazillion experts. They have all these people saying he's the leader. You don't need the lyrics.
To your question, but my point is to use the art, to assume that is statements that the state argued are confessions. That's what they said. These are confessions.
Okay.
They said
that shit's unbelievable to me. Pardon my language. If you're new here, I talk however I want. I don't love the government. You'll never find a fan of the government with me. You're not going to see pro-police. You're not going to see pro-judge, pro-prosecutor. It's not me. I don't like the government. So welcome. But if you want a government-loving commentator, find somewhere else to go. Okay. Sorry. So Brian
we
Steele
didn't go out and find them. Mr. Williams
is saying they have everything they need to prove their point.
handed them to us. These are his.
These are, the state is saying these are confessions. Well, there's a lot of laws about confessions, and I don't know all of them because I don't practice in the criminal arena, but there are lots of rules about confessions. And just off the top of my head, these are not confessions. This is art.
His inner workings of his mind. But it's an artistic industry that our courts now, for the first time, this is the first time in Georgia, our court has said in footnote 16, we got to be careful. And they cite to these cases that say you got to be careful.
Careful. One thing I don't understand is why these people sound like Yankees when they're Southerners. Careful. And they don't say y'all. I don't understand the dialects coming out of Georgia at all. Like, maybe Steele grew up in New Jersey or something. We got to be careful. Like, that is not... I don't know. Anyhow, they speak differently in Georgia than we do here in Texas, y'all.
The next case cited by the our highest court is United States versus Gamory, Gamory, and that's 635 F 3rd 480. It's 11th Circuit 2011. Again, it's in footnote 16 of the Baker case. And on the copy of the opinion I give in this honorable court.
Okay, so the Baker case is this new case where the Supreme Court says, this rap video was more prejudicial than probative, and we just talked about what probative is.
And he owned hush money entertainment. These facts are not seriously contested at the time the video was introduced.
Okay,
and
he's
such
talking about the
evidence
Baker case.
And therefore cumulative. Was there for cumulative.
And about
in short, the probative.
That it was cumulative.
Not changing anything.
What YSL Steele is saying, the Baker case is not that it's a rap video. It's that the video was cumulative, and it was more prejudicial than probative. So YSL Steele, Brian Steele here, is making the same argument. He's saying these lyrics are cumulative, and they're more prejudicial than probative. And that's a good argument, and Glanville completely ignores it.
Thing I relied on. I heard what the honorable court said, and I did understand you to say that the state has to lay a proper foundation before they can admit any of these, but that foundation now, according to Baker, is really tied hard to specific facts and not just generalities. That is my argument.
So Baker's the new case?
Thank you, sir.
Thank you, Your Honor.
All right.
Now we have my favorite lawyer, Max Chart. I think Brian Steele, YSL Steele does a great job. I just
Mr.
really
Shard, I'll
like
give you the
Max
opportunity to
Chart's
make your
style.
argument now, or you can
Here he
wait till
comes.
I finish with.
Also, love his outfit
Because
today.
you've got some similar, probably, argument. So
I didn't hear the last.
I said you got some similar argument. That's what I was.
I heard you say I could make it now.
Yeah.
Okay, so Max Shark gets up and starts talking specifically about a video his client Shannon Stillwell's in. And like one of the facts this video shows is that he's wearing red. wearing red is now a crime in Georgia. Like, he's wearing red. Well, guess what? Miss Love has worn red a ton of times in this trial. It's unbelievable. So Mr. Shart is going to show the judge the video to show the judge how it's cumulative and how it's prejudicial and why it should be excluded.
I've unmuted.
Look how young little Shannon Stillwell
Hey,
is.
Mr. Kokomo. You know how I can sound?
Okay,
None
I'm
of
skipping
the-
through that. The video is awful. The music is. It's just a bunch of kids waving around in front. I mean, we've seen videos like this on this trial over and over again.
Those statements, robbing drug distributors, that has no direct nexus to any substantive charges in this case. Keeping a stick has no direct reference to any charges in this case.
Okay, so now Shard's main argument is there's no direct nexus. So that must have been language that came out of Baker also. I didn't read Baker. But so Steele is saying it's cumulative. Shard is saying there's no nexus.
I just beat a murder rap. Paid my lawyer $30 for that. Now, I think it's fair to say that that is most likely a reference to being wrongfully arrested back in 2015 for the murder of Donovan Thomas. He was arrested in October of 2015. He stayed in jail for a long time as his co-defendants' cases had their preliminary hearings, were dismissed. Eventually, the state dismissed cases against all three other individuals that were charged in that case, along with Mr. Stillwell. Mr. Stillwell was granted bond, and
So the state dropped their charges on that case when they were talking. This is the murder of Donovan Thomas. Yet here we are 10 years later in a courtroom hearing about the murder of Donovan Thomas. This is why I don't like RICO. RICO is this bullshit catch-all. When you didn't have enough probable cause, you didn't have enough evidence back when it actually happened, and now all this time passed and you collect all these lyrics, which don't even tell you anything. Now you're going to go retry it? No. Like, our government should not be allowed to pull that kind of crap. All right, so he goes on. Blah, blah, blah.
this is the trial.
Okay, all right. So basically, your client's alleged participation in this or commission of this murder is fairly contained with this indictment, correct?
Correct.
Okay, so why wouldn't that be considered potentially a statement against interest or?
Because it's not against interest. He's just stating a fact. He was charged with murder.
Okay.
I mean, that's not against interest.
I know, but you have a choice as to whether or not you want to say anything or, you know, one of the.
We live in a country where there's no double jeopardy. So if I'm charged with murder and y'all drop the charges, well, I guess that's not double jeopardy. But if I'm charged with murder and you drop the charges, I am going to tell people that. I'm going to tell that. Lauren Cadillac, not even some, kid. If I was a kid making music videos, of course I'm going to tell people that. I beat the charges. I got this whole thing going on my own on the side. I can't wait to come out and tell you all about it. I cannot wait to come tell you how I beat charges. So for the judge to say, oh, well, this is some kind of admission. Yeah, an admission that the government couldn't prove a case against me. So why are we here talking about the case they couldn't prove?
The beauties of our Constitution is, hey, you can, a couple things. You certainly have a freedom of speech, but certainly you have, advice of counsel. And certainly you have the issues of whether or not, whether or not you make statements that are against your interests. And especially if you put them in a song,
So you're supposed to go to your lawyer and have your lawyer
you potentially
review
might
all
have
your
been
music
involved
lyrics.
in, not just, and I'm saying that nexus is something that.
Could you imagine if Queen had to go to their lawyer and have the lawyer review all of the lyrics? Bruce Springsteen had to go have all his lawyers review his lyrics. It's ridiculous. why would hip hop be the one place where you have to have your lyrics reviewed by lawyers? What does hip hop have that other genres of music don't?
A little bit, Baker speaks to where the court's got to look at in footnote 16. That it's not like not like he's not involved in the video. He's prominently posted in the video, and it's not like somebody else is attributing those statements to him.
No.
So, I mean, I think it's a little different.
Well,
I feel like this judge is grabbing onto minutia to help make it different to argue the case for the prosecution, which is weird to me, but I think that happens a lot in criminal courtrooms.
Fair prejudice, as it is used in 403, refers to the capacity of some conceitedly relevant evidence to lure the fact finder into declaring guilt on an improper basis rather than on proof specific to the offense charged.
Boom! We don't need to go any further. Boom! We can't use it.
Citing to Old Chief v. United States, 519 U.S. 172.
I'm gonna relax.
Generally, such improper bases for a finding of guilt include a criminal defendant's bad character or his propensity for violence.
Okay. And we already know that his client has bad character and has a propensity for violence. They've already come out and admitted, like, yeah, my client sold drugs, he did these bad things, blah, blah, blah. All right, so the government hired this guy. This guy, I guess he just argues motions, because I've never seen him, like, in the courtroom except to argue a motion. And I have to be honest with you, he really bothers me. I do not like him. He reminds me of people in law school that I didn't like.
We have Stillwell saying the words. You can see him saying these words. I just beat a murder rap. I paid my lawyer $30 for that. Me and my signs above the law.
Kind of feel like $30,000 is cheap for a murder rap, but that's just me.
And we're told that that has no relevance to a charged count in this indictment and to overt acts under the RICO count 1 of this indictment. It's a little
Guys,
bit...
I never noticed this guy till now, but he's like hiding behind the TV, thinking that people aren't going to see him. He had a mask on standing over here earlier. Now he's like, oh, he still has a mask on maybe, but he's like hiding behind. We can see you, buddy.
To me, it's a stretch. But the fact that the Supreme Court in Baker didn't consider the lyrics at all, let alone analyze them under 801.
As an attorney, this is the kind of shit that really drives me nuts. Just because they didn't analyze the lyrics in that particular case doesn't mean that the analysis of the lyrics in this case doesn't apply. To hyper focus on the analysis of the lyrics tells me that that case actually loses you. Your position is lost. When someone has to find a hyper minute, tiny thing and focus on that, let's say you and a loved one, you live together, the loved one wears the same pair of shoes to the gym every day. And you wake up one morning and those shoes are there, but the loved one isn't there. And you're like, oh my God, are they alive? Are they okay? And then you say to the loved one comes home, they're fine, they're upset. Like, why were you mad? Well, I wasn't mad, I was worried, but I thought your shoes were missing. And since you always wear your shoes to the gym, I thought certainly you wouldn't be at the gym. And if you were in that same position, you would be concerned too. If your loved one, always wore my gym shoes and my gym shoes were here, and now suddenly they're not here. And then your loved one says, oh, but you go to the gym at a different gym than I do. Okay, that's not what we're talking about. Do you understand what I'm saying? So this guy is focusing like it's a different gym. That to me tells me they lose under this new Baker law. When you have YSS Steele and you have Shard come out and they can both say legal reasons, not comparing facts to facts. They say this is cumulative, and then Shard says there needs to be a nexus. Those are legal reasons. Those are winning reasons. These facts of it was a music video where he didn't rap and this is a music video where he does rap, you lose. In my mind, this is why I'm not a judge.
Makes this case in a different universe than the lyrics we have here, because it's just not talking about statements. It's not
It doesn't. It's the same. It's crazy.
a statements case. And then lastly, a big difference that I noticed in Baker is that it's, again, it's a single defendant murder trial, whereas here we got a multi-defendant
So the facts of the case are different, and that's why you should treat my case differently. I absolutely hate that argument. I think it's stupid. I think you lose in it. But no surprise here. You win if you're in front of Glanville and you're the prosecution. All right. So Glanville says, no, even though Baker is out and there is a nexus and it is cumulative, I'm still going to allow it. But then the funny thing is, after he hears this, this prosecutor doing his argument, Glanville says, let's take a 10-minute break. And then he comes back an hour and 30 minutes later. Hold on. Here we go. So the kid talks. All right, here we go. Glanville goes on break. Hold on. Says we're going to take a 10-minute break. And here's where they come back. And for the first 5 minutes, he just shuffles paper. Mister, I'm so worried about how long this trial is taking. It's too much, these guys. I swear, this man does not hear the words coming out of his mouth.
Over other similarly situated persons.
So, that was the lyrics hearing. I'm trying to figure out which one is which. Okay. So, the judge had come in on Tuesday. They were supposed to start on Monday, but there was a funeral. So, the judge comes in on Tuesday, and he says, okay, they do the Supreme Court thing. The judge takes 2 breaks. And when he comes back, this is so crazy, on Tuesday, well, at one point, the judge gets mad at the prosecution because they were supposed to bring in a statement of how many witnesses they had left and an estimate of time that it would take for those witnesses. And when they came in on Tuesday, even though Miss Love was supposed to have that for Monday, she didn't have it. And so Glanville was like, part of the reason this is going so slowly is I'm giving you deadlines and you're not meeting them. And so he got really irritated, and instead of actually doing something, he just came back with a new kind of scheduling order. And I'm hoping this is the right clip.
To defend DeMontre Kendrick's motion to limit witnesses filed on the 1st of April of this year. Counsel, I've had an opportunity to read your...
Sorry about that. Everyone that's come back. I don't know what happened. My video just... I don't know. The internet must have died on me. Who knows? Okay, so... Glanville had read all the motions. He heard the motions about how long this damn thing is taking. And the Weinstein, I think is his name, who wrote the motion that said, hey, we're going to be here for 2 years. He told the judge in 2004 the average attention span of American was 2.47 minutes. And now it's 0.45 seconds. He said, we're losing the jury. I'm watching them be lost. Now, that's not going to be good because the jury is going to end up deciding this whole case on closing arguments. All right, so here we go. Let's get back into
motions. And I really don't need any oral argument on it. I'm going to go ahead and give you my thoughts, okay? And then we can talk any further if necessary. Let me start out first by a brief procedural history of where we are and where the court thinks we are.
Let's do this. This is great.
Which you can correct as need be. This case was indicted, or we had and/or arraignments May of 2022. The court then started having proceedings over the summer of 2022. We started motions on or about the 20th of December of 2022. We summoned jurors for
April of 22. April of 22. We are in April of 24. We're already 2 years deep into this.
For January of 2023. We selected a jury on or about 15 November of 2023 and started the presentation of evidence soon thereafter. And up to this point in time, of April the 2nd, I should say, of 2024, we have summoned some 40-something witnesses.
Oh my God.
At this point, in terms of just a rough framework of what has gone on in this particular case. Now, in reading your
2 years already, and we've had 40 witnesses. Wow.
issues, Mr. Weinstein, as well as Ms. Love, in terms of the delay. I'm going to group them in two separate, because I don't want you all pointing fingers at one another, and there's enough blame to go around to everybody, all right? But there seems to be two issues and two categories that issues kind of get presented. And the first one is, even though the state has released tranches of discovery over the course of the past year, some of it is untimely, and it caught.
Finally. Finally. Some of it is untimely. The state is handing them Instagram posts from last night. That is untimely. How are we sitting here for 2 years and you don't have every witness and piece of evidence ready? We've been in trial for 2 years and you don't have witnesses and evidence ready. You're still bringing new crap from last night? Get out of here. Unbelievable.
This is information evidence that the defense claims that they haven't seen, or has been augmented, or has been, they just didn't get. And a big example was last week when we had the testimony of Ms. Bennett. And even though there were interviews and or text messages that were available, they were not disclosed until the witness was on the stand. Now, the court understands the ebb and flow of trial and understands that sometimes things happen. And in taking a look at the appellate case law that we've talked about earlier in regards to exclusion, and this is not the first time the court's been asked to exclude evidence by the defense or made such arguments. Mr. Steele has made these arguments before. Mr. Weinstein has made these arguments before. And several of you have made these arguments before in terms of just of non-disclosure and that they should be excluded. But that's just one example of...
Okay. If it was not disclosed prior to trial, it should be excluded. That's trial by surprise. Like, we don't do that. That's not an American value. That's not the way Americans try trials. Okay, no. Secondly, this judge just said there have been multiple times that the defense has said this should be excluded because we've never seen it before, and I didn't exclude it. This judge just admitted his error on the record, out loud. There have been, these guys made this objection, these guys made this objection, these guys made, and I didn't exclude it. So he's admitting right now what he did wrong. So I'm pointing at the screen, y'all. So
where the state could have and should have provided those particular statements earlier.
Yeah.
And text messages.
Because that's your job.
And what this does is,
that's the law.
when we have a jury seat in the box.
We already know what it does. So now he wants to talk about, like, that's the reason it's taken so damn long. But there's a lot more reason to it, buddy. It's because we have hour-and-a-half breaks every 5 minutes. All right, Miss Love gets up. She just got stomped by.
Because I wanted to know how many more witnesses and how many more days.
This is where,
and I told you ballpark and the evidence that you on this.
I just want to say, finally, maybe Glanville should be going to freaking funerals every week, okay? Because he got back from the funeral and he finally said something to the damn prosecution. One, you got to give up your file. That's how this works. And two, I told you to bring a list of all the witnesses. So here we go.
Hilton, and your team is kind of putting together, but that's not ready, is it?
Your Honor, what we have been factoring in was the fact that we will not be in court. So we have got...
Okay. he said that's not in, is it? And instead of just saying yes or no, oh, Your Honor, what you asked was this. This is why Lauren Cadillac is not a judge. Okay, because Lauren Cadillac would say, that's not what I asked. Answer the question that is asked of you, Miss Love. So, if you ever see Lauren Cadillac running for judge, y'all, please come have someone take my temperature. Call my eldest son and say, Noah Cadillac, please call your mother because something is wrong with this woman. She is running for judge. There is a crisis here. Okay, I am having none of that. I am not going to, I don't have this in my life. If I ask you a question, you answer the question I asked you. You don't give me some answer that doesn't relate to it. Because then in response, that's not the question I asked. So Miss Love, she knows she didn't bring the list. Just say, no, I don't have the list. You know, like, I'm a grown-up, right? And so, like, if I miss a deadline or something, I say, yeah, I'm sorry I missed that deadline. That's it. Okay, here we go. God, I can't stand this woman.
I just asked
The answer is that is not ready in this.
how many days more of trial do you think that your case in chief will take?
I could
30, 40, 50, 60? Tell me how many more days you think you're going to have. I asked you to come up with that number because that's...
that,
All right, you
She
sit there and
hasn't
think about it.
even
I'm going to come
thought
back
about
to you in
it.
just a second, okay? But this is the challenge because it's been brought to the court's, allegation that I'd like to... While you all need to try this case, and it needs to be fairly tried as to both sides, we
Oh my gosh, y'all, I can't. Okay, so he finally,
have
Glanville
jurors
did
that,
kind of
we need...
a little bit abscond Miss Love, which she deserved. She has been doing too much the whole time. In our next scene, it's like, in our next scene, and then we have this, and then we have that. We didn't get to see, we saw Thug in some pictures, by the way. He's dressed really great. He's been wearing a lot of sweaters, which I like. All right, so this is day 53, which I don't even know what day of the week that was. I know on Wednesday she said this is a very, 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 very rough draft. I think that's this day. So let's get to it. Let's see.
Or very, very, very rough estimate.
Oh my gosh, y'all. This is what I just told you she said. How perfect that I pulled it up. So on Wednesday, she's like, this is a very, 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 very rough estimate because she is not going to be held to any damn deadline. Lawyers are so lawyery. It's almost like funny at times. I love it. She absolutely is not going to be held to a deadline. She is giving you a guess of a guess of a guess. And here we go. We're going to keep going.
Can we shut that
Has
door back
the
there if you wouldn't
testimony-
mind, please?
I apologize, Your Honor.
And my thought was not complete. So, have you turned over or tendered to make sure that that the discovery that matches these particular witnesses has been turned over already?
Okay. This becomes a huge issue here in a minute. Basically, what the judge just asked is, have you turned over each piece of discovery that's going to come out on each of these witnesses? In a civil trial in Dallas, in the DFW area, in any of the counties in Dallas and surrounding areas, I would assume in pretty much the entire state of Texas, in a civil trial, I have to have to you a list of witnesses and discovery 7 days before we go to trial. And if I hadn't already disclosed those to you at least 30 days before the trial, they're not coming on. So in Texas, I'm not going to get to trial and be surprised at what witness has what piece of evidence. All they're asking for is witness and the evidence you want to present with them. Witness name, evidence you want to present with them. Watch this woman fight this.
Yes, Judge. We've
You scrubbed that again, and have you met with defense counsel, or are you assured that that all of the documents that are turned over have been turned over that are responsive to these witnesses. And what I'm asking is so that when a witness is called, and like I said before, if we have a situation where that document has not been tendered, or you can't tell me when it was given to the defense, if you tell me we gave it to the defense on February the 15th and it's in the same form, and they tell me, well, we haven't seen this, well, then we're just going to go forward. But if not, like I said, that's when I'm going to exercise several other options. So are you sure of that? Are you sure that you've tendered everything?
I'm fairly certain, and Judge, what we've been doing is prior to each of the acts, what we've been doing is sending over our exhibit list along with the witnesses that we intend to call for the upcoming weeks. So we will continue to do that. And if there was an oversight, error, or omission, not with respect to turning it over, but with respect to just alerting defense, we'll be using this exhibit in this act or with this witness, that I believe should cure any concern with respect to those issues. Because that's what I believe that's what we have continued, that's what we've done, and that's what we will continue to do.
The challenge that we've had is that defense counsel either says that they have not received that, okay, or it's an augmentation of something you gave them. So, for example, the discovery you gave them may have had.
I don't know why he has to give an example. She knows exactly what's going on. She's been sitting in that courtroom.
15 pages. Now it has 25. It's more complete. Or, as I mentioned a couple of days, yesterday, that you found something the night before from an Instagram search.
Witnesses are we using those with?
Okay, so she says 120 more days. Oh, at one point she says she doesn't want to put the witness. She says she doesn't want to put the witness with the evidence because she's not the legal secretary of the defense. I'll agree, you're not the defense's legal secretary. However, you're the only one with a burden here, and you need to show them how you're going to meet that burden. And you need to let them know ahead of time so that they can fight you. Like, that is our job. That's the job. That's the job you chose. That's the career choice you made, Miss Love. Like, it's not being a legal secretary. They gave terabytes of evidence. Terabytes. I don't know how big that is, but it's really big of evidence. You can't just hand the defense a terabyte of evidence and say, oh, here you go. And the defense doesn't know out of she said there's still 150 more witnesses. We've already heard 40. So out of damn near 200 witnesses, I'm supposed to go through terabytes of evidence and just know which piece of evidence is going to go with which witness? Get the F out of here. God, I can't stand her. I hate Miss Love. Oh, they showed a video. I gotta get... Y'all, today is going to be long. Okay, so... Stay focused, Lauren. After this, we're going to go to the part where Brian Steele moved to make Miss Love a witness. Okay, let's get through this first.
So that's false. In the short time since that was stated about 10 minutes ago, I went back and looked at the witness lists that we were given on January 7th, February 9th, February 16th, February 23rd, February 25th, March 15th, and March 25th. And while we were provided that list of witnesses as ordered by the court, and I believe that the state was following the court's orders, those witness lists did not include lists of exhibits.
So she said, oh, well, we've always been doing that, so we're going to keep doing it. And YC said, no, you haven't always been doing that. I have a list, but no exhibits. So I got names and no exhibits that go with them.
She has made that representation. I would love to see that going forward. If we could get a list of the exhibits that they plan on presenting, along with which witnesses they'll be using those with, I think that would certainly make this a more efficient process, John.
Mm-hmm.
Your Honor, if Mr. Weinstein was looking only in the emails with the list and not in other emails, he may have overlooked what the state has provided, but
He's looking at lists. And there's a list of names, but not a list of evidence. That's all the judge is asking for. You you don't have to win every little thing. Like, you can lose a battle and still win the war. And everything does not have to be a battle. I just think about this woman, like, if she were my mother, like, what nightmare it would be. Or my spouse or something. Oh. She would just fight every little point until it died. It's like, it doesn't need to be that way, y'all. You can win, like, on a broad scale, and lose in small things. It's okay.
I'm quite certain that we have provided in advance of our showing or tendering these exhibits, we have provided them to counsel for the defendants. And I can go through our emails and find those emails where we've done that.
That's great, Your Honor. If that's the case, I'm more than happy to hear it, and I would look forward to that going forward as well.
I like
and
it.
Maybe if those were coupled with when we receive the witness list, we would get a spreadsheet with that list along with the exhibits that are going along with the witnesses. We could look at those exhibits in advance and maybe be better prepared to make this a more streamlined process.
And Your Honor, we have provided more spreadsheets than we could ever hope to get. And Your Honor, we don't intend to catalog our list. We did that initially with the acts that we intended to present, the witnesses that we intended to present per act.
Another thing I need to know is, how can you present a case without a catalog? Okay, I have a deposition next week, right? The way I prepare for my deposition is I have a bunch of stuff and I'll write my questions, right? I'll have my pleading open. I'll have the elements of each, in their case, it would be the crime. You know, I don't do criminal, but each civil thing. I have each element. I write the question and then I put show da-da-da-da-da. That's a piece of da-da-da-da-da being the piece of evidence. Show them XYZ piece of evidence and ask them about XYZ piece of evidence. And then now to the next one. So if I have a witness, that's for a deposition. When I'm going into trial, I have all that again. Maybe it's in a different order. Maybe I don't like some of the pieces of evidence. I don't know, whatever. But I still have that. There's no way I'm walking into a trial in a courtroom, especially in front of a jury, and I don't have a list or somewhere of this is the witness and these are the pieces of evidence I'm showing. How can you call yourself prepared? Don't forget there was a whole argument where the judge called YSL Steele unprepared. And now this woman is saying she doesn't even have a witness and evidence list? Who is truly unprepared here? Ugh. Her. She makes me sick. That's me getting
When we
sick.
provided the witness information, I'm certain counsel has resources available to do that for them, but we do not intend to do any more cataloging for the defendants.
I'm not asking them to do any more than they've already represented to the court that they have done.
Ugh. I'm just asking them to do what they said they were going to do.
If you go back and look at the transcript from today, you will see that the state has said that when they provide those witness lists, they also provide a list of the exhibits that the witnesses
You
will
did
be
say that.
They
testifying
did say
And I
that.
mean-
Okay, so finally we got Glanville piping in. All right, what's Max saying over here? I love the sweater that Thug is wearing.
But I'm not going to do it in front of a jury like we've been doing before.
No, I
I'm
understand.
not doing that anymore.
I understand, but
Okay, so what is that incumbent upon you to do then?
well, I'm going to reiterate the fact I completely understand that you want to be forewarned about issues. I'm just going to reiterate reality that unless the plan is to have us go through thousands and thousands and write thousands and thousands of particularized motions, we do need the pared down, and I believe that's what the state's saying, but I'm just reiterating, we're going to need the pared down list ahead of time when they seek to introduce recordings so we can file.
Okay, so the judge has said that, you know, part of the reason they're going so slow is because y'all are just moving to exclude this when you should have already moved to exclude it. And Shard is saying we can't move to exclude it previously because they're not giving a list with who and what is gonna be presented. And so that's true. That's true. If you don't tell me prior, like, how are they supposed to prepare for it? I don't know. I don't know. Okay, so now I'm going to try to find, if you recall, last week, YSL Steele, after Attorney Love read all these text messages between her and the defendant, which was crazy, she essentially made herself a witness. I'm trying to find the video for you. Okay, those text messages, the defense still hasn't even seen them. Still hasn't seen the text messages. They're under seal. And the defense, the text messages came that morning. Nobody knew about these text messages until that morning. So what Shard was just saying is like, we need to know beforehand because we need to be able to write motions to exclude this evidence. And here's the thing. If you don't give me all the evidence that you're going to present in the next 2 weeks, then the judge is going to have motion after motion after motion, which is unrealistic. We need to have it all presented up front so we can do one motion with all of the pieces of evidence. We got a great comment here. We have greeting Cadillac Law. I can't stand her or oh my goodness, me neither. Her or Fannie Willis. They do not represent all women, and I am one and have honor and integrity, and I live in Dallas. Well, Toothless Tiger, thank you for joining us, my fellow Dallasite. I'm so happy to see you here. I know you have honor and integrity, and look, no, I know lawyers like Miss Love. Okay, I know, like I was just talking about the battle and each little minutia, you know. I know lawyers who will go toe to toe on a detail that doesn't matter. Those are not good lawyers. She is not a good lawyer, and it's sad that she's in such a position of power. It's sad that she's able to subpoena people, have people arrested. I mean, it's awful. To have a personality like that, have so much power potentially over our own lives, that's exactly what our Constitution is trying to prevent. All right, so let's go. Here we go. Here's Thug in a brown sweater.
And this may frame your argument.
Usually I don't like brown, but I do like this.
Because you've got case law, and certainly to the extent that you need to invite my attention to it, that's fine. But I'm more interested in those conversations, if any, that were not witnessed by a third party. So
okay.
What I'm saying is,
where we are now is this was yesterday. Okay, so they came in Tuesday, Wednesday, Thursday. So I did take notes, y'all. I am taking notes for you. This is where they're arguing, YSL Steele is arguing that Miss Love should be disqualified because she has made herself a witness. Now, in his argument, he actually plays video of her doing it. So let's get into that. Here we go.
what she purportedly said. I don't necessarily know if that's memorialized in text messages, so I don't want you to go down that rabbit hole thinking that, you know, that that's all there is to it, okay?
The question, yeah, that's great. The question, I appreciate it because I'm not privy to that. The question, though, asked was, did you send communication? Send to me would be an email, U.S. mail, or a text message.
Okay.
So
All right, fair
anyway, Mr. Kokomo, with the court's permission, if he's available to do it, just play them. They're very short, and then I'd like to answer your question.
Okay, so now YSL Steele is about to play videos.
Is that okay?
Yes, sir.
Which is fun. We're all playing videos of videos
keep
now
that.
at this point in our lives.
And the record should reflect that there's also some people who write in on this at the bottom. And specifically, I'd like everyone to take note that a person who's very, very well respected on following trials said Keith Adams is a phenomenal lawyer. You will see that.
Let me just pause right here. Keith Adams is a phenomenal lawyer, and you are about to see that. Just look at this man's posture as he asks these questions. Look how comfortable he is in front of the jury. Oh, hold on. Before we get into it, I got some more comments. Thanks, y'all, for participating. I super appreciate it. I'm so excited you're here. Glanville took all day beating around the bush, and he explained his denial of the motion. I was like, spit it out, Judge. Yes, he did. He took an hour and a half break when he could have taken 10 minutes, and the irony should not be lost on any of us. And he was very clearly going to rule in favor of the prosecution from the beginning, and so he did go ahead and waste everybody's time. Toothless Tiger. I've looked in your community. Remind me of. I know others. These people have horrible. Oh, okay, well, I definitely appreciate you joining me and my channel. I don't know who Cynthia and Scotty Allen is, and I definitely have one of the strongest work ethics I've ever seen in a human being. I love working. So thank you, Toothless Tiger, for being here. Make sure you hit like and subscribe, all of you. Make sure you hit subscribe. You want better sound and video? You want me to not look as fat anymore? We got to hit subscribe. I got to be able to afford a new camera. Okay, here we go. We go back to the videos.
Isn't that self-serving? I just wanted, I still want to see if I still got it, okay?
Look at that. Look at that posture. Dude is comfortable in front of a jury. Is he even sweating? Y'all, the reason I love these suits is because they hide the sweat, okay? This man doesn't even look sweaty.
Discuss with Mr. Anderson that Jeffrey Williams was going to pay for the heroin that Buck had stolen from your apartment.
Objection, Your Honor, that would be hearsay, and there is no exception for it.
Number one.
Unless, Your Honor, someone is on the list to prove that up, which there is not.
There is. She cannot.
Yes.
Miss Love is messy.
Okay, there was. This video is a video of someone else making comments. Their comment was Miss Love is messy. She is a messy lawyer. So the state's lawyer, the guy who just does motions, whatever his name is, he later argues that Miss Love just made in this instance, she just made a speaking objection. Well, guess what? Speaking objections aren't allowed for a reason. It's crazy. All right, he said Miss Love is messy. Okay, Steele gets back to his argument. Oh, while I talk about this, if you're here in the chat, why don't you tell us if you think the judge will actually disqualify Miss Love? If you don't know, you haven't seen the result yet, let me know what you think it's going to be. Okay, now Steele plays another video.
I will rule the objection.
Did you tell anyone in the district attorney's office that the judge could kiss your ass?
No. I told Mr. Hampton to have the judge to call me so I could tell him I've been harassed. That's exactly what I said.
You got permission to treat the witness pursuant to Brown?
I'll allow.
So, Your Honor, where I heard the initial part of the question was the same communication thing. Attorneys all have this, with an explicit whatever message to the court, whatever the words are. So, I target that. Answer your question
Sorry, guys, that's their sound, not mine.
directly. So those are 2 points that I'd like only Ms. Love can answer. Then Ms. Love talked about on redirect, which was hostile witness cross-examination. Talked about meeting with Ms. Bennett on the bench outside of your court.
But don't you have to object to preserve?
Okay. So Steele finishes his argument, and the judge says, well, you didn't object at the time that it happened. And Steele's like, I don't have to. And the judge is like, well, the state said your objection's untimely, and you do need to object. And Steele's like, no, I made my objection when I made my motion, and I don't have to object in that instance. So the reason that's important is there's a rule that you have to make an objection to preserve the error for the record for appeal. And you have to do it in that moment. If I ask you, is the sky blue? And you say, I went to the grocery store yesterday as a response. if I don't say objection, non-responsive, which they don't have non-responsive in Georgia, but that would have been my objection here. If I don't object to that and get that on the record before the next question, I'm out. So if someone's testifying and they're asked, is the sky blue? And the person says, well, blue is a combination of green and yellow. And I need to object to that because somehow like the way we make blue is like at issue. But or whoever the other side says, well, do you like yellow? I can't object to that last question. It's over. And so here, the judge is arguing that Brian Steele should have made the objection at the moment it happened. Now, I'd argue he laughed a lot when it happened. And I just think Brian Steele is too good of a lawyer to miss an objection. I feel like if the objection needed to be made, he would have done it.
Or let the court know at that point in time. That's one of the issues that the state's raised, is that you all failed to timely object.
The state was wrong. The state was wrong.
Respectfully, because
Oh,
this
good.
is
Why
not
is he
on
finally turned on
appeal
the...
where I didn't ask for her to become a witness. The case that the state cites is the contemporaneous objection rule when you want to stop the question. Ms. Love decided voluntarily and freely to interject herself in the proceedings. There's no objection.
Okay, so Steele is saying I couldn't object because she interjected herself freely.
No, you still have to
Becoming a
object.
witness. No.
I disagree with you. You still have to object as soon as you realize that there's an issue, that to preserve the issue so that the appellate court doesn't kind of tell you waiver, right?
But what's the issue?
The issue is what you just told me.
No,
that she's injecting herself as a witness.
And that's okay.
I mean, that's what your allegation is.
That's okay, though.
Okay, but that kind of at least preserves the issue for the.
But it's not a legal objection. There is no legal objection. State is becoming a witness. That's not a legal objection.
Court to consider then and make a ruling on it.
The court is considering now, did Ms. Love become a witness in the case?
All right, then the other thing is we haven't completed the examination of Ms. Bennett. So all the conversations, and this is why I asked you to kind of limit as to the conversations that you believe Ms. Love had, and there's no other third party, because you can certainly examine the witness about those particular statements that were allegedly made, or the third party can be examined.
Okay, so then Brian Steele gets into, okay, well, the thing is she's talking about these text messages between her and Miss Bennett, so there is no one else to examine except Miss Love. And so now I need to be able to cross-examine Miss Love so I can ask Miss Love what she meant when she said to Miss Bennett, did you send a text to the judge that said kiss my ass? All very valid points. Okay, the state's attorney gets up and he says,
at some point,
no, that one was a talking objection, and two, every communication Miss Love made was with another witness. And so it's concluded that Agent Hamilton can now come and testify to what Miss Love meant when she was talking about the kiss my ass message. So for those of you who didn't know or couldn't have guessed, the judge obviously said, no, Miss Love is not a witness. Crazy. Okay, we got Toothless Tiger. I knew I did. Started to watch the case. Oh, wow. You just started to watch the case a week ago. That's wild. Well, you could definitely go back through my live videos. I've done updates throughout. No, not throughout the whole 2 years that the case has been on, but I've been doing the updates since the jury's been seated and since there's been like actual evidence presented. So welcome to the shit show. Crazy. All right, so next week our jury's supposed to return on Monday. There was no court today because on Tuesday, Wednesday, Thursday they just did these motions and they had maybe a half day. The jury returns on Monday. Now in Dallas and throughout big sections of the United States, we're going to be experiencing a solar eclipse, which I'm very excited about. I got my little special glasses. I was going to come to the office on Monday, but they're now saying that people are going to be like pulling over on the highway just to watch the eclipse, and that it's going to be, traffic is crazy, and that like every Airbnb in the whole town is rented. So since that's the case, I'm going to just take my trusty laptop home and work from home and enjoy the eclipse from home. But of course, I'll be watching this trial in the background, as I always do. I'll watch commentary later, as I always do. I am, just obsessed with these trials, and I love being able to share them and my thoughts with y'all. So for everyone who came today, and I had quite a few viewers on the live, I really appreciate it. Another CG and Toothless Tiger, thank you so much for participating in the chat. I think it's so fun to be able to communicate with people. For those of you who are watching this later, certainly feel free to give us your comments. I do respond to all of them. Make sure you are hitting like and subscribe. Look at the rest of my content. And of course, if you need a good civil lawyer in Dallas, give me a call. Thanks for joining me, everyone.